Good morning, folks. We'll give it just another minute or two. Looks like folks are making their way back in. Right. Seeing, looks like most of the folks are back in at this point. So good morning, everybody. I think you all know me by now, but in case you don't, just a reminder, I'm Curtis Bryan. I'm the field manager for BLM in the Wenatchee field office. And I'll be your facilitator for today. We're going into day 4 here. We've got a good agenda set aside. Really appreciate all the feedback that folks are providing to us in those end of the day after action reviews. That information is invaluable to us as a group. It helps us make this course better every year, and so keep that as we go through this. Keep that in the back of your mind, and don't be afraid to share your thoughts with us at the end of the day. So I think we'll get right into it. First thing this morning, we've got Jason Cirksena, and he'll be giving us a little presentation on fire trespass. So.
All right. Hey, good morning, folks. Jason Cirksena. I'm currently the fire prevention officer for the Idaho Panhandle National Forest. Background in fire prevention, mitigation, investigation, trespass between state agency, Bureau of Land Management, and now with the Forest Service. I'm going to go ahead and share my screen here. And if I could just get a thumbs up when it looks good. All right.
Good to go.
All right. Hey, we've got about 45 minutes here. We've got a dense process that we're going to explain about fire investigation and cost recovery, also known as fire trespass. We'll have about 10 minutes at the end to discuss in our small groups, and then 5 minutes back with the large group to share those outputs. So with that, I'm going to go ahead. I'm going to turn off my camera. And if somebody could monitor the chat, I'd appreciate it. And we'll jump right in. So what's the purpose of fire investigation, trespass, and cost recovery? Ultimate goal of this is to help us aid in prevention planning, the pursuit of criminal action against violators, and the collection and recovery of resource damages and suppression costs through administrative or civil processes. So what does all that mean? When we talk about prevention planning, by having those specific causes through fire investigation, we can then target specific locations and actions engaged in by the public to mitigate fire starts. It's a more financially and time efficient way to deliver these effective programs. For example, if we have an area that we know has a history of target shooting fires, we can then message to the public or have emphasis patrols there. Same with dispersed camping and escape campfires. If we know of these problem areas through fire investigation and through our fire prevention patrols, we can then better plan how we're going to address that. Pursuit of our criminal actions. What do we mean by that? By providing a base of information and facts, we then can help work with our law enforcement and our fire prevention staff to address these issues and crime on our respective jurisdictions. When we do that, when we address the issues that we're seeing on our landscape that are causing fires and or maybe criminal in nature, we're creating a culture of accountability on our respective lands that we're managing. And that word travels through the public. And you have to excuse me, folks, I've come down with a little bit of a cold. So if I cough or go on mute for a little bit, I'm just coughing and trying to spare you the noise. And then what do we mean by collection and recovery of resource damages and suppression costs through administrative and civil processes? We've got 3 different ways that we can pursue cost recovery on negligently caused fires. And we're going to talk more about that later in our presentation here. But the thing I really want this group to take away is that we have a fiduciary duty to the public to hold individuals responsible for the cost of fire suppression when a fire is negligently or intentionally ignited on our respective jurisdictions. In short, what I mean by that is it's not the public or the taxpayer's responsibility to foot the bill for fires that are negligently or intentionally caused. And that's part of our responsibility as fire managers and as agency administrators. So, what's an important part of this? And an important part of this whole process is understanding the laws and policies that govern cost recovery within our specific agencies. Per the Red Book, Chapter 18, fire cause and determination with trespass and investigation, agency policy requires the determination of cause, origin, and responsibility of all fires. The jurisdictional agency must pursue cost recovery or document why cost recovery is not required. I've got the policy and where you can find information for each specific of the 5 federal agencies that fight fire. I don't have it for the state agency and the state folks that have here. But I know between Oregon and Washington, both have robust fire cost recovery programs. And would just say that grab this slideshow at the end of this if you're interested, and go ahead and look through and find your agency specific policy. So for the BIA, we've got the 90 IAM backed up by the 25 CFR. BLM has the Fire Trespass Handbook 9238 backed up by the 43 CFR. Park Service has got the Reference Manual 18 backed up by the 36 CFR. Fish and Wildlife Service is found in your Fire Management Handbook backed up with the 50 CFR. And then the Forest Service has manuals 5130 and 5300. And I'd just ask folks, check your mics if you don't mind muting. I'd appreciate it. So that's where we derive our authority. But as we've talked about, not all fires are always the same. And we have at times multiple agencies involved in a fire. And that means that we could have multiple agencies that are involved in a fire trespass if a fire is determined to be negligent and crosses that boundary. So who's got what responsibility in that scenario? The agency with the land management jurisdiction administration role is responsible for determining the cause of the ignition, identifying the responsible party, obtaining all billable costs, performing the billing, collection of funds, and distributing collected funds. Meaning that if there is money brought in, it can be collected on behalf of another agency, and then it needs to be distributed. That gets into a little bit more administrative processes and making sure we have authorization to collect on behalf of other agencies. But again, you'll have a staff and you'll have a subject matter expert that should know and help you through that process. Another wrinkle in this, if there's an agency providing fire protection on behalf of another agency, that agency that is providing fire protection on lands that are not theirs jurisdictionally, they must provide initial determination to the land management agency that has jurisdiction. Again, a very important part of this is that all of this should be defined in our cooperative fire protection agreements. Again, see Chapter 18 in the Red Book. Excuse me. So what are the roles that we have in here in this process? We're going to tackle an FMO's role first. There are a little bit of differences between the different departments. Within the DOI and traditionally within state agencies, fire management officer has the overall operational responsibility for fire cause determination and investigation and trespass. Candidly, folks, the Bureau of Land Management and BIA and the state agencies have a much better and well-defined process than any of the other DOI agencies or the USDA. Within the Forest Service, the way it's broken out is that law enforcement investigations, they have the overall responsibility for ensuring that fires are investigated. And that being said, it's important that an FMO or duty officer has strong relationships with with that LEO staff to ensure that these actions are actually being conducted. Uh, on the Forest Service side and USDA side, this comes back to that fire protection officer qualification and folks being required to have that, and that being supervised under the law enforcement shop. That being said, again, I just want to reiterate, it's very important that as fire managers, we take a strong role in having a strong relationship with those folks and making sure that this is done. So within that, what does that mean? What are the responsibilities? We need to ensure that all fires are investigated, need to determine that cause and origin, again, for prevention planning, for holding folks responsible for negligently caused fires, etc. Provide adequate staffing and training for fire investigation and trespass program. Ensure the initial information regarding the report of a fire is documented by dispatch to inform the fire investigator and be included in the fire investigation trespass report. You know, pretty simple. It's a long way of saying we need to make sure that we have fire investigators that are getting dispatched and they're communicating with our communication centers to get any sort of information, if that's wildcat logs, weather reporting information, etc. Ensure notification of law enforcement when appropriate. Ensure the completion of all appropriate documentation pertaining to the fire investigation in a timely manner. For example, in the Bureau of Land Management, there are timelines associated with initiating fire trespass and with the various steps along the way to collection. Ensure the investigation report moves through the required process for determination. Again, there's typically an administratively determined process by your agency for how these things move through and a determination is made. And then ensure involvement and coordination among resource specialists, finance personnel, law enforcement, and agency administrator to complete the trespass process. So what's an agency administrator's role and decision space within pursuing trespass? AAs have the overall responsibility for wildland fire investigation and trespass on their unit. This will be outlined by your delegation of authority and your respective operating plans. Some things to remember on this: the decision to trespass cannot be made before the facts are gathered. We need to have a completed fire investigation and a determination made by an agency attorney before we proceed and make decisions. Determination to proceed needs to be based on facts, not the cost or ability to pay. So on one end, if we know that someone does not have the ability to pay, we cannot just write off this fire. On the flip side, if we know somebody has the ability to pay, but the facts may not all be there yet, and we don't fully know if they were fully negligent, we can't just pursue the cost because we know this person can pay. And at the end of the day, I want to make a note on this. Our goal in pursuing cost recovery on negligently caused fires is not to leave anybody destitute. Our main goal is to change behaviors and ensure that that individual is held responsible and that the public is not bearing the brunt of paying for a fire that was negligently or intentionally caused. Agency administrators should also consult with their agency attorney advisor to determine if there is liability to proceed with fire trespass actions. These agency attorney advisors are huge in this process. They're going to be a guiding light for you as an AA. In the DOI, it'll be the solicitor's office. In the USDA, it will be the Office of General Counsel. And with our states, I believe it'll be your assistant attorney generals. Those folks are going to help guide you through this process and help keep you on the correct path and have you proceed in a way that is commensurate with how the law is written and how our agencies expect things to be done. We have 3 different avenues available for cost recovery on wildland fires. We've got administrative processes, we've got civil and criminal. Civil and criminal obviously being through the court system and being adjudicated that way. We'll talk a little bit more about that in the next 2 slides. But the most common way that we pursue cost recovery is through administrative processes. Keeping it out of the courts, it allows us to be more efficient and effective and quicker than taking something through the court system. And that's the way that we usually typically prefer. That being said, if there's elements of a crime, do need to work with law enforcement and investigators and our agency attorneys to determine what the best way to go is if there is a crime associated. Per 31 U.S. Code 3711, the AA has the responsibility to bill for the total cost of the fire and only the authority to accept full payment. That's a big one. And we're going to talk a little bit. There are ways to negotiate, but as an AA, you only have the authority at this stage to accept, to bill for the full amount and accept the full amount. Per 28 U.S. Code 2415, the government has a 6-year statute of limitations from the start of the fire to pursue a trespass claim. So we've got that 6-year statute of limitations. Follow your agency DOA for process of compromise or termination of claim. Throughout these processes, people who are thought to be responsible or are responsible for causing negligent fires or potentially negligent fires are going to be given an opportunity to provide more information that could maybe negate the claim. Or maybe we find that we want to negotiate with this individual because the cost is so exorbitant that we feel like their behaviors will change and we want to find a way to compromise with them and not leave them destitute. There are traditionally processes for you to compromise. As an AA, those compromises need to be approved at higher levels. For example, within the Bureau of Land Management, a compromise needs to be approved by a state director. And there's a whole process set out with briefings and working through with your state office staff and the BLM. But just know there is a process there, but it will require higher approval. The determination to proceed or not proceed must be documented and filed with the unit's official fire report file. Within the BLM, we have looked at going towards fire trespass case management system. More to come on that. I'm not going to dive deep into that today. We don't necessarily have the time, but just know that you do need to document why you are or are not pursuing. All right, wrapping up here. As an AA, you really need to fully support the training, funding, time, and equipment for fire investigators. Build those relationships with law enforcement, fire management, fire investigators, your business, your fire business staff, your agency attorneys, and upper management support these actions. This is a process that you're not going to deal with, very regularly. And so having that team built up and folks that you can ask questions of to help guide you, it's very important. And then work with those folks to build a process that works for you. At the end of the day, you have the responsibility for this. Make sure that it flows in a way that you're happy, you're getting the answers and the support you need to make the best decision as you enter into this process, because it can be a bit contentious. All right, a couple more slides here, and then we'll get into our breakouts. So we talked a little bit. There's 3 approaches that we can take to pursuing cost recovery. We've got our criminal, administrative, and civil. They can be pursued, obviously, either administrative or judicially. Our criminal and civil enforcement being judicially. In that scenario, you'd be working with the U.S. Attorney's Office to work on getting those funds. Those funds in that scenario would then come back to you in the form of restitution. The way that works, restitution be ordered by the court. It gets sent to the Treasury Department and then back out to our respective agencies. This is very laborious, very not necessarily, it's very expensive and time consuming is a better way to say it. And our preference is to pursue things administratively if we can avoid that civil. That being said, if we are going to see a case pursued this way, usually that means we've got a healthy element of crime or we've got a very large cost on a fire associated with it in the civil arena. Another thing of note with that is that administrative and civil cases cannot be pursued concurrently. We have to choose which route we're going to go down. We can't choose to pursue in 2 different ways, hoping one will stick. And so our last slide here is one of our most important. want to talk about negligence. I'm sure a lot of us are familiar with the definition here. The failure to exercise a standard of care that a reasonably prudent person would have exercised in a similar situation. Our four prongs with this is there's a duty. The duty is what a reasonably prudent person would have done or not have done, depending on the circumstances. There needs to be a breach of that duty, failure to act as that reasonably prudent person. There needs to be proximate causation, the link between the actions or lack thereof, and the injury to the plaintiff, which is our damages, right? So that would be our injury would be our cost in suppressing that fire and or our cost to rehabilitate the land. The agency has the burden to demonstrate negligence by the preponderance of evidence to justify an assessment for cost recovery. And determination of negligence is a fact-specific inquiry, meaning there's no bright line rule, and each case is different depending on the facts of the matter. Just like a fire, every trespass case, since it is dealing with a fire, is a little bit different. All right, so we've got a breakout room scenario here. On July 5th, a fire occurred just outside Prineville, Oregon on BLM administered lands. The fire burned 3,000 acres of BLM private and state and had multiple air and ground resources that responded. The fire closed State Highway 342 south of Prineville for approximately 2 hours, and multiple residences were evacuated. Property loss was amounted to 2 outbuildings and a few miles of fence line. The approximate cost of the fire was $300,000. BLM and state fire marshal investigators found fireworks at the point of origin and of the fire, and witnesses noticed 4 juveniles on dirt bikes near the fire area. After a fire investigation that included interviews, photographs, and written statements, the 4 juveniles were found responsible for the wildfire caused by the use of fireworks. In your groups, let's go the next actual 7 minutes talking about the following. What questions stand out to you in the case as the agency administrator? Are there any state statutes that deal with juveniles? And what course of action would you suggest with the juveniles? All right, let's take 7 minutes back at 44 after, and we'll have groups 5, 7, 9 report out. All right, head to your breakout rooms, please. And thanks for your patience. All right. I believe I said groups 5, 7, and 9. Please correct me if I'm wrong. But group 5, why don't you tackle our first question here? What questions stand out to you in the case as the agency administrator?
Yeah, good morning. Some of the stuff we talked about, does state law allow damages to be assessed to the parents of juveniles that were found? Did they actually commit a crime? Were they within the laws of using the firework? Was it appropriate or not? And then kind of with this first one, can juveniles be held accountable themselves, or does that go somewhere else? And then, what was their intent? Is there kind of more intent behind it within intent to cause a fire, or was it just kind of accidental, or how that goes? So
Absolutely perfect. Yep. So on that question, you'll be able to work with your attorney advisor on if parents can be held responsible or if juveniles can be held responsible. State laws are going to be different. I know in the state of Washington, I believe it's 13 years old. You're expected to know right from wrong, and you can be held accountable. But I also believe you can pursue with parents in that regard too. And the intent part, very important. I'm glad you brought that up. We talked about that in our group as well. For example, a handful of years ago in the Columbia River Gorge, there was, I believe, a 16 or 17-year-old held accountable for $36 million based upon making statements and showing clear intent of intending to start a fire by throwing a mortar, right? And large fire. So great responses there. Group 7, our second question: are there any state statutes that you're aware of that deal with juveniles?
Yeah, we weren't really sure on this one, if there was, and we weren't, being that this was multi-jurisdictional as well, with between BLM, private and state there, who would be the pursuing party for this case? Would this be under state jurisdiction? Would this be under federal jurisdiction? Or is this a civil case for seeking private damages there? That was definitely, we had a lot of questions for our OGC working for the Forest Service there to get some clarity on what our legal authority is versus the adjacent state agencies and then private landowners.
Perfect. Absolutely great, Josh. That's exactly what we were hoping to facilitate with that conversation. Go back, trust your agency attorneys, have those conversations. Where did that fire start? Who's got the responsibility for it? Who's going to be handling the investigation, cost recovery? Perfect. Thank you very much. All right, last question. Group 9, what course of action would you suggest taking with the juveniles?
Sorry about that. So I guess the things important to consider, obviously there's the fire investigator's recommendation, possibly agency attorney if you've made it to that point. But like you said before, like considering the intent is very important. Just especially with the juveniles involved, and obviously this is going to be a sensitive situation. And then, I guess kind of your obligation is to recoup the cost, for the taxpayers, but there's a lot of things to consider there. Does it cost more to try to, pursue the costs, and, what are the social implications of that? I guess there's just a lot to consider there. So.
That's great, Janet. Thank you. Yeah. You nailed it. We have a potentially dynamic scenario that we need to weigh. And then we also need to fall back to our authorities and what we can and can't legally do. One creative way that we can resolve these issues on a very innocent end of the spectrum, lacking intent, and with folks that have done their best to be honest and transparent with us that may have started fires. A lot of times people aren't aware that your homeowner's insurance will typically carry a liability rider with it. Meaning that one thing that we could consider as agency administrators is pursuing a compromise and a settlement and getting that approved further up, and just settling for the amount, that a liability rider will pay out. It's happened before. There's good precedent for it, but that may be one way that we can do that. But hey, great answers. All right, folks, I ran 6 minutes over. I'm going to turn back time now. Thanks for your attention, and thanks for all the interaction. So this will be in the portal, and Curtis, back to you.
Well, thanks, Jason. You're actually 8 minutes ahead of schedule, so
am I? I thought I was supposed to be done at 45. I'm sorry.
Nope, you're good, man.
Yeah.
So
right.
I guess if there's some questions still, we could probably have some time for that if folks wanted to throw some questions out there.
Hey, Jason, this is James Dickinson, BLM. Just to maybe open up some questions for other folks, but you mentioned the resources that agency administrators need to be able to provide to their investigators and prevention folks. One of the things we found has to do with kind of the space required for evidence. If you want to speak to kind of some of those needs and some of the issues that can create on some of our compounds and government facilities.
Yeah, absolutely. Dealt with this specifically in the Spokane District BLM. So there needs to be clear chain of evidence when it comes, a clear chain of custody when it comes to evidence, What that has looked like is, and that is traditionally tracked with our law enforcement folks. That goes into their LEMIS system that tracks all evidence collected. Needs to be secured. There needs to be a clear chain from collection on site all the way to being stored back at hopefully your respective office, or if the law enforcement has an agreement with another agency to have secure storage because our facilities don't meet the requirements, that may be a case that you might have to do that. The real world example is that in the Spokane BLM, we worked with our law enforcement officer to build a evidence storage lockup that met the requirements set forth by law enforcement investigations. We then always worked with that individual to, anytime we collected evidence, we would follow it, or we would hopefully have that law enforcement officer come out to the scene of the fire to collect that evidence, so it was cleaner. But there is a process, chain of custody for collecting that evidence, and then the storage being very important. Work and defer to your law enforcement staff. All of our law enforcement staff should hopefully have either in-house evidence storage or have agreements with interagency partners to have storage at their facilities that is secure just to our for our BLM folks or for our Forest Service or whatever agency it may be. Does that answer the question for you, James?
Yeah, it did. Thanks, Jason.
Yep.
Good.
Looks like
Tommy.
Yeah, hello, Jason. I think I brought this up the previous 2 years in this class too. It's just kind of more of a comment, or maybe you can clarify. It's just the use of the word trespass. Seems like kind of a broad word or a new definition of the word trespass.
Well, it may seem that way, but it's pretty old, written into the laws, right, and to our policies. So the true definition of fire trespass within the DOI is the existence of unauthorized fire on Bureau of Land Management managed lands, and that could be intentional or unintentional. So it sounds funny, but think of it as the fire existing where it shouldn't be, and it's trespassing onto your lands where it's not wanted, right? And the other thing important, and this is for our BLM folks, in order to pursue on that administrative side, fire actually has to burn onto BLM administered lands to pursue administratively. If we are fighting a threat fire that never makes it onto BLM lands, then the only real way to pursue that is civilly. Or if our partners, say it's private land and our partners with the state are pursuing those costs, we can work with them to submit our cost and have them collect on our behalf, and then have those funds remitted back to us. So does that help, Tommy? Or
yeah, that did help. Thank you.
Yeah. All right, any other questions? Oh, and I see. Well, and I want to clarify, Cassidy, threat fires can be eligible for cost recovery. It's just a different process. We may have to pursue civilly or work with our other agency partners if they're pursue on our behalf. So there is still a way. It's just a different avenue to get there. All right, folks, last call. Anybody seeing any questions?
I think we're good. Thanks, Jason.
All right. Thank you all.
Cirque.
All right. Well, that'll take us into a break, folks. Why don't we go till 10 after the hour, and we'll be back here to talk incident business with Veronica.